screwed something up. Should I tell my lawyer, or will that make things worse? As regular viewers know, legal consideration focuses almost exclusively on the attorney-client relationship in the business law context, that is, on corporate and transactional matters rather than litigation. But I'd like to emphasize here, criminal law matters are out of scope of this video. If you've committed a crime and you intend to keep committing crime and you're actively planning your next crime, other than, asking you on behalf of society to consider not doing that, the issue of whether, when, and how much you should tell your lawyer about your ongoing and future criminal activity is way out of scope of what I can opine on in even a casual way. The second caveat here is that you need to ensure that the person that you refer to as your lawyer is really your lawyer and not your company's lawyer or the lawyer that you share jointly with your business partners. One of my earlier videos responded to the question, can my lawyer disclose information to my boss or my business partners or my spouse? And that's a good place to learn more as well. Depending on your position and any fiduciary duties you may have, the extent of the screw up and the potential consequences to you and your company, it may be vital that you have your own independent counsel who represents your interests only and who has no duty of disclosure to any third party under a joint representation agreement. But today, I'm really focusing on the business law clients where no joint representation issues exist, when the client hasn't necessarily committed a crime, but has made a substantial enough error that significant legal liability or other major repercussions are now potentially in play. Situations like mismanagement of contracts. So the client signed a contract without having a lawyer review it and without really understanding what it meant. Now the company is obligated to conditions that it just cannot fulfill, but the client is embarrassed to admit to the lawyer that he thought he could handle it himself. Or mishandling of employment issues. So the client was dismissive of employee complaints about a bad actor at the company, or the client mishandled an employee termination, and now the impacted employee is threatening a lawsuit. The client is afraid that if he admits that he failed to investigate complaints, or if he shares documentation that suggests that the employee was terminated for impermissible reasons, it'll make the situation worse. Or negligent behavior. So the client made a terrible business decision, or engaged in inappropriate conduct in a professional setting, or acted negligently in treating a patient or a customer. And now the client is concerned that once the facts get out, his reputation will be ruined, or he'll be fired, or he'll be subject to disciplinary action or regulatory sanctions. Admitting what happened to a lawyer makes it real, and the client is still hoping that the situation might just blow over. So I cannot emphasize enough how common these situations are, and I truly do empathize with the complicated, difficult emotions that the client confronts when going through them. Now, with that said, I cannot think of a single instance over the course of my entire career where the client would have been better off continuing to withhold information from me. I can, however, think of multiple instances in which the client made things much more difficult for himself by lying or by failing to give me the full picture of what had transpired. As lawyers, we are duty bound by extremely strict confidentiality obligations, and we are ethically required to provide you with competent and diligent representation. And this is true even if internally we cringe when you tell us what happened, or we're exasperated that you acted against our recommendations, or frankly, even if on some level we find your behavior distasteful. In earlier videos, I've discussed the extreme circumstances in which an attorney can disengage or essentially fire their client. And if you've behaved in a way that is so abhorrent that the lawyer believes that she cannot in good conscience continue to represent you to the best of her abilities, terminating the relationship is in both your interests. Don't worry, there is another lawyer out there for you. But short of that, and until the disengagement is official, the lawyer is duty bound to represent your interests to the best of her abilities. At the risk of sounding patronizing, we are far more likely to react the way a parent does to a naughty child. Although we may be frustrated that you disregarded our advice and disobeyed, we still love you and we still want what's best for you, and we're going to work with you to fix the situation the best we can. But we can't do that unless you're transparent with us about what's really going on. Frankly, if you're dealing with a lawyer who's been practicing for a decade or more, it's unlikely that whatever's happening with you right now is the most outrageous situation they've seen. We have seen and heard a lot, and that experience helps us to assess and mitigate risks and keeps you from compounding mistakes that we've seen similarly situated people do in the past. It also means that even if an exasperated sigh occasionally escapes, we really aren't judging you. You're allowed to ask your lawyer for reassurance that your conversation will be privileged and confidential, and your lawyer will give you advice, like making sure you don't share the details of the conversation with any third parties, to ensure that privilege continues to adhere. But once you have that assurance, it will almost always be in your best interest to be fully honest with your lawyer so that they can help you navigate the issue and develop the best strategy to reduce any further harm. Business owners, do you trust that your lawyer has your best interest at heart and that anything that you tell them will remain strictly confidential?